Good afternoon to those of you in the East, and good morning to everyone else across the country. Today's webinar will focus on a specific aspect of the SEC's Municipalities Continuing Disclosure Cooperation Initiative, whether the SEC can establish that a misstatement relating to compliance with continuing disclosure obligations is material within the meaning of Section 10B of the 34 Act or Section 17A of the 33 Act. To help us explore this topic are four panelists. First, Norman Goldberger is joining us. He's the partner in charge of Ballard's Securities Enforcement and Litigation Group, and he is a co-head of Ballard's Multidisciplinary Municipal Securities Enforcement Practice Group. Norman will provide an overview of materiality, both in terms of the applicable legal standards and how materiality may be proven. Second, we're delighted to have Dr. Vinita Juneja joining us. Nita is the co-chair of NERA's white collar group. NERA, by the way, is the National Economic Research Associates. She is the national co-chair of their white collar group, and she focuses her practice primarily in the areas of securities, economics, finance, and valuation. Nita will discuss how materiality may be proven through economic analysis. Third, Terry Gornascia will present. Terry's a partner in Ballard's Public Finance Group, and after we lay the groundwork of the legal and economic analysis, Terry will discuss some practical applications of the materiality standard. Lastly, I'm John Grugan. I'm a partner at Ballard in the litigation department, and I focus my practice on SEC enforcement. Along with Norm, I'm a co-head of our Municipal Securities Enforcement Group. What I'd like to do to start is to provide a brief overview of how we got here with this initiative, including a quick summary of what participation in the MCDC initiative requires and some of the consequences of participating. On March 10, 2014, the SEC's Enforcement Division introduced an initiative to encourage self-reporting. It's encouraging self-reporting by municipal securities issuers and obligated persons and underwriters of possible securities law violations. And this relates to misrepresentations in offering documents concerning an issuer's prior compliance with its continuing disclosure obligations. The MCDC initiative is just the latest SEC effort in a long campaign to require timely, accurate, and most importantly, perhaps from the SEC's perspective, uniform secondary market information from issuers. Some of the SEC's past efforts include indirect regulation through municipal securities underwriters, including through the March 2012 SEC OCIE Risk Alert. The SEC also has conducted press campaigns. In July of 2012, it issued its comprehensive report on the muni market, and in that report, the SEC, through that report, the SEC sought legislative changes to the Tower Amendment that, had they been granted, would all but have repealed that amendment. The SEC also has sought increased market transparency through the MSRB. It has tried to place pressure on disclosure and secondary market trading through FINRA, and obviously it has brought a number of enforcement actions, some of which we'll talk about today. Before the City of Harrisburg case in 2013, and despite widespread reports of issuer noncompliance with at least some continuing disclosure obligations, the SEC had not brought a related enforcement action against an issuer or, at least overtly, emphasized SEC Rule 15c212 in its enforcement actions against underwriters. That obviously has changed recently, and that's exactly what the MCDC initiative is designed to address. The initiative has received a great deal of press. We've done a couple of webinars on this, and so have many others, and so I want to run through an overview of it rather quickly just to hit a few high points. First, under the initiative, the Enforcement Division will recommend favorable settlement terms when there has been self-reporting. Again, I think you all know this, but the Enforcement Division can only recommend settlement terms to the Commission. It can't actually agree to them. It's ultimately the Commission that will make that decision. For eligible self-reporters, the Enforcement Division will recommend settlement through cease and desist proceedings that do not require any admission of liability. It says that it may recommend not levying a financial penalty against issuers And with respect to underwriters, it may recommend tiered financial penalties. Last week, after tremendous pressure from the defense bar and also through industry groups, the SEC announced some revisions to the initiative. The deadline for underwriters to self-report remains September 10, 2014, but issuers now have until December 1st, 2014 to self-report. Second, to encourage smaller underwriters to self-report, the SEC announced a tiered penalty approach under which underwriters of a reported annual income of more than $100 million may face a maximum fine of $500,000. For underwriters with reported annual income in 2013 of between $20 and $100 million, the maximum fine would be $250,000, and for underwriters with total annual revenue of less than $20 million, a $100,000 maximum fine will be considered. Also, the SEC stated in recognition of the fact that the NRMSR system was decentralized and unreliable that it would take into account good faith efforts to discover CDA violations that were hampered by the inefficient NRMSR system. What is required to be disclosed? This again is well worn, but I do want to touch on it just so that we all understand some of the consequences. Obviously, the contact information must be self-reported not only of the reporting entity, but also of the participants in the transaction. The role of those individuals will certainly be explored, and obviously the facts that attend to any instances of noncompliance will have to be described. With respect to that, the description of the facts and circumstances surrounding the instances of noncompliance, anyone who participates in the program ought to note that the statement can't be withdrawn if the Commission presents unfavorable settlement terms, and also it may serve as an admission in subsequent proceedings, including litigation. Lastly, a certification is required, which obviously presents other issues when making a certification to the government. In prior webinars, we've discussed a number of issues that attend to this submission, including the potential impact of the statement as an admission, and also whether conflicts of interest may exist where individuals who previously certified compliance are those now making the decisions about whether to self-report. These are obviously considerations that need to be explored prior to approaching the government, but we're not going to dig too deeply into those here today. Some additional considerations. The initiative extends only to misrepresentations concerning CDA compliance. Individuals may not self-report. There is no protection that is being offered to individuals, whether individuals at the obligated person or at the underwriters. So issues concerning supervision of those who were involved in the self-reporting, in the certification of compliance, all of that's on the table. In addition, entities that self-report will be required to cooperate, and those who cooperate reasonably should expect that there will be referrals to other agencies, including FINRA. The third and fourth bullets here on the screen actually raise an interesting issue. While the Enforcement Division has made the statement that those who do not come forward will feel the wrath of the Enforcement Division, that it will come down on those people and those entities like a ton of bricks, is the quotation from the SEC. It's interesting to note that, at least with respect to whether or not the SEC will penalize municipal issuers, it has done so in a single case. Last year it came out with, it announced the Greater Wenatchee case, and that was the first time where there was a fine issued against a municipal issuer. The SEC noted and took great lengths to make this clear that the fine was being sought only because the proceeds, the fine itself would be paid from proceeds that were not taxpayer money. that is consistent with a longstanding SEC policy of not making taxpayers essentially pay twice, both for the initial misconduct or the loss attending to the initial misconduct and then a fine. So while the SEC has been very clear that it intends to be very aggressive with issuers who do not come forward, whether or not they ultimately would come forward and seek a penalty is a matter of some debate. What is driving a lot of this is the Tower Amendment. I won't go through the Tower Amendment in any detail, but what the SEC is concerned about could be perhaps best summarized in reference to a 2011 study by DPC Data, which found that for fiscal years 2005 through 09, for any of the 5 years, at least a third of the expected disclosures were never filed in the designated official repositories. In 2008 and 9, the non-disclosure behavior rose to 36% and 40% respectively. For the period of study, 56% of issuers or obligors did not file annual disclosures for 1 or more years, and 19% did not file for any of those years. A similar study by the California Debt and Investment Advisory Commission focused on 2010 annual disclosure filings for bonds in its database that were issued between 2005 and 9. And that study found that only 72% of issues sampled met their obligation to file on time. Almost 10% failed to file at all. So what has the SEC done? In last year, in July of last year, it announced the West Clark Community Schools matter. The West Clark Community Schools matter, though, while it is probably the first of the cases that really leads to this initiative, in a lot of ways is a rather straightforward case. In that action, again, it was the first action where a municipal issuer was charged with falsely claiming in an official statement that it was fully compliant with continuing disclosure obligations. However, West Clark had not submitted any of the annual reports or notices for a 2005 bond offering. And based on the fact that nothing had been filed, in a lot of ways, this case presents an outlier and may serve as a very stark contrast to what many of our clients are facing today, where there may be 1 or 2 foot faults, but certainly there has not been just a blanket failure to file. So with that background, we'll turn to Norman, who will discuss the statutory authority for the MCDC initiative.
Thanks, John. There are 2 basic statutes that are in play here, and they are related to one another, and for this purposes, we don't need to spend very much time in talking about the distinctions. One is, of course, our familiar friend, Section 10B of the Securities and Exchange Act of 1934, and also Section 17A of the Securities Act of 1933. For those of you who are litigation mavens and enforcement practitioners, the main difference is that the Securities Act of 1933 has been held to have a lower standard of culpability. That is, one need not plead scienter in connection with Section 17A, and one does need to plead Section 7 in 10B cases. One does need to plead scienter. For the purposes of this discussion, that really doesn't have any, to coin a phrase, material impact. So with that, I'll move to materiality, and we'll talk about what materiality means. Interestingly enough, the Supreme Court's definition of materiality has only been in existence about 40 years, notwithstanding the long history of the 2 Securities Acts. And even more interesting, the seminal decision on materiality does not arise out of Section 10B, nor does it arise out of Section 17A, but instead it arises out of Section 14 of the Securities and Exchange Act, which has to do with proxies. I raise that because the definition was, at that time, targeted to the particular case in front of the court, notwithstanding that, it has been broadened to encompass all of 10b-5 and all of Section 17, but because of the stretching that needs to be done, given the way it originally arose, you'll see that what appears to be a very straightforward announcement of what materiality is, and is in fact not such a straightforward announcement. But in TSC versus Northway, as you can see, the Supreme Court held that a fact is material or information is material if there's a substantial likelihood that the disclosure of the omitted fact would have been viewed by the reasonable investor as having significantly altered the total mix of information made available. A lot of words in there. The first thing to notice is that it is an objective standard. It is not what a particular individual thinks is important, but what a reasonable investor, the hypothetical reasonable investor, would have thought was important in altering the total mix of information made available. The second point is to go on to note that the court rejected a different standard, which was a standard that would have required issuers and others to disclose any information that in any way could affect the business of the issuer, and instead opted for this standard. Its reasoning, it did not want to overwhelm recipients of information with trivia that would distort the marketplace. The theory being that too much information was in some ways as bad as too little information. We can all argue about whether or not that is an appropriate result, but that is the result the Supreme Court has opted for, and it has remained unchanged for the last 40 or so years. That has had enormous consequences because, taken literally, these words could result in outcomes that we would all disagree with. Let us take the most simple example. The famous Basic case, which in its second holding, there were two holdings, one of which is addressed by Halliburton, not the subject of this seminar, but in its second holding held that, in essence, merger discussions between two companies is not a material subject for disclosure unless and until those merger discussions become some form of serious. That's a simplified explanation, but close enough for these purposes. I would submit to you that any reasonable investor would in fact like to know about any merger discussions. They would not like to know just about serious merger discussions, but any merger discussions, since such merger discussions can affect the price, often do affect the price, and certainly can affect an investor's decision whether to stay with, invest in, purchase, or get rid of particular shares of an issuer. Nonetheless, notwithstanding its standard and notwithstanding its emphasis on the reasonable man standard, the court looked to its second pronouncement in TSC, which is that we don't want to inundate the market with useless information. And it said that information about a merger that may never take place, that is only in discussion stage, rises to the level of useless information which might distract a reasonable investor. Again, I leave it to you to determine whether you think that's an accurate reading, but it shows you that one must take into account not only the test enunciated by the court, that is substantial likelihood, but this idea that there is too much noise in the marketplace, and that noise in the marketplace is not appropriate for investors to hear about, and that issuers, as a rule, need not make statements about noise. As time went on, various and sundry problems presented themselves to the courts concerning materiality, and they reached various ad hoc solutions as to whether something was material or not, to the point where several commentators have noted that materiality has become very similar to pornography, and Justice Stewart's famous statement that I know it when I see it. That, of course, is not terribly helpful for those of you who are trying to decide whether or not to submit to the SEC's current initiative. So we'll try and give you some further guidelines. First, it is clear that that information which can be demonstrated to affect price of the issue is almost definitionally material. In each instance in which one can show an impact on price, there are no cases that hold that that is not material. The opposite, however, is not true. The mere fact that there is no impact on price has not been held to absolve an issuer from liability. It is a factor, and it's a factor which I know Nita will discuss and which we'll discuss a little bit further in a moment, but it is only one factor. Volatility, that is, the degree to which investors react to news or facts, is also considered to be a proxy for materiality. That is, if traders in the marketplace, in fact, react to information in the marketplace, that information must be material, it is thought, because otherwise the traders would not react if you can show cause and effect, another problem that I think Nita may address. The degree to which analysts pick up on information is also viewed as an indicia of materiality, because analysts are considered to be experts in the field. If they think something is important, then of course it must be important, and therefore that might lead to a finding of materiality. So this is difficult in this instance because of the nature of the material misrepresentation that all of you are interested in, which is that you have either failed to file your required statements on time, or there's been an omission in the filing of your statements. So let's address that. The SEC beginning in the 1980s to establish a different standard, something that came to be called ethical materiality. That is, corporations were required and issuers were required to disclose to the public that there was some wrongdoing within their organization, regardless of its economic impact. The reasoning for that was that participants in the marketplace would like to know about the integrity of their corporations and of their issuers, and therefore the investing public was entitled to know that. That view took its most prominent form in the overseas payment scandals of the 80s, and Congress addressed that issue directly with the Foreign Corrupt Practices Act. The reason Congress decided to enact the Foreign Corrupt Practices Act, in large part, was because the courts almost unanimously rejected the SEC's proposal for ethical materiality. The court's view was that materiality goes to the issue of price, it goes to the issue of the finances of a company, it does not go to the moral character of a company, and that investors indeed do not invest on the basis of the moral character of a company, but rather on its financial performance. And the cases began to pile up from the Third Circuit, from the Second Circuit. They never reached the Supreme Court, but numbers of cases began to pile up, all of which held that the proposition of self-accusation of wrongdoing could not be a proxy for materiality. And so all of that went out the window, and it was thought to be resting quietly until about 1999. In 1999, the staff issued its Staff Accounting Bulletin number 99, entitled very simply Materiality. It purported to address an accounting issue. That is, to what degree would numbers have to be misstated in financial statements to be considered material? And it purported to address the question of whether there was a per se rule. That is, if you were off 3% of your financials or 5% of your financials or 10% or 10% in a category, would that per se give rise to a finding of materiality? The SEC rejected that test and said there is no per se rule, there is no safe harbor below which you can feel comfortable. And in fact, and it went on to say, broadening its pronouncement beyond financial statements, every omission has a qualitative aspect to it. There is a qualitative analysis that must be done with respect to every fact or omission to determine whether it is material. And it introduced the following concept. It said, if management of an issuer deliberately misstates its earnings, no matter how small, in order to benefit itself or in order to hide its failures or in some other way that would be viewed as self-dealing or self-aggrandizing, then that is a material omission because the investing public is entitled to know that the issuer's management is doing that. That sounds a whole lot like our old friend ethical materiality. And indeed, when that was implemented, the commentators raised the old cases. The SEC refused to back down, but not surprisingly, it has not acted on SAB 99 with respect to that aspect of it because it's always able to find actual materiality. That is, what it has been able to do with many issuers, or with all its issuers, what it's been able to do is to find price effect or volatility effect whenever it wants to bring a case. And so it's not had to rely on this qualitative materiality issue, this ethical materiality issue, until now. In this arena, we should compare the two definitions, which we've now got on the screen. The first one is substantial likelihood that the disclosure of the omitted fact would have been viewed by the reasonable investor as having significantly altered the total mix of information made available. That's the TSC Northway standard. Compare that with, there is a substantial likelihood that a reasonable investor determining whether to purchase the issuer's municipal securities would attach importance to the issuer's failure to comply with its prior continuing disclosure undertakings. They have told you in that statement, and that's out of the Kings Canyon case. They've told you in that statement that they are going to determine what the subject of materiality is. They are going to decide that a reasonable investor cares about the failure to comply with prior continuing disclosure undertakings, and that they're going to measure the relative worth or the relative materiality or the relative importance of the particular disclosure in question. But frankly, that puts the rabbit in the hat. The first question is whether or not the particular misrepresentation or omission is in fact material under the TSC Northway case. The SEC cannot define its way out of the Supreme Court's definition of materiality. So the question isn't whether the particular disclosure undertakings is so severe as to be failure to disclose is so severe as to be material, but rather whether any failure to file or failure to comply with the obligation to file is in fact material. I think for purposes of this argument, one could agree that the complete absence of the filing of promised disclosures over an extended period of time is likely to be viewed as material under the TSC Northway test, on the ground that, in fact, when officials of an issuer fail to file any of their disclosure obligations, they are displaying indifference to the well-being of the issuer, and therefore that would affect the financial health of that issuer. But it gets a lot stickier if we begin to probe into what the actual facts of some of these cases are. For example, let us assume that you have a situation in which there are 5 years of disclosures and one has forgotten to file one table. Is that material? Or let us assume that one has filed 3 years worth of disclosures but not 2 years worth of disclosures. Would anybody care? Under the TSC versus Northway test, without putting the bunny in the hat under the Kings Canyon test. What we have to look at is whether there are any available means to test that. Price is unlikely to be available. Once the disclosure is made, I think we're going to find, and I think Nita's going to tell us, that it is unlikely that price is going to be affected. If price is affected once the disclosure is made, well, there you have your answer. And we can, as Nita will explain, look to other situations where disclosures have been made to find that out. Similarly, we can look to see whether or not volatility is affected. We can also look to see whether the failure to file fits under any of the other cases that have ever come up with respect to material findings. And the answer is, the closest they come to is these allegations of improper corporate behavior. And those cases, as I've said, always held that you don't have to accuse yourself of of improper behavior under the securities laws. So where does that leave us? Well, it leaves us in conflict. The materiality definition of the Supreme Court in TSC versus Northway is much, much different than that of the SEC in the Kings Canyon case. I would argue to you that it is substantially a higher burden under TSC and substantially a lesser burden. And while it is true that the SEC in the first instance will have to enforce and will enforce its own test, when the courts get a hold of this, as will eventually happen, they will be applying TSC versus Northway. And I think under that test, the materiality determinations you all have to make will be significantly different. And with that, I'll turn it over to Nita.
Thanks, Norm. Let's start out with going from what Norm has just described to what kind of economic analysis can be done to help assess materiality of alleged undisclosed information. In this example, I'm going to use a hypothetical issuer, Smalltown County, and a bond series, Smalltown County Bond Series 2010A. In this situation, we're going to say that this issuer allegedly failed to report a cut in state aid that significantly reduced revenue. Now, to make it even simpler, we're going to assume that this information is not made known to the public unless the municipal issuer discloses it. Next slide, please. So here we see our hypothetical issuance and the prices, and we have a time period where disclosure allegedly should have been made, and then a hypothetical what is being asserted would have been the price had the disclosure been made of reduced state aid. As I said earlier, if this was something that was disclosed elsewhere somehow, even though the issuer hadn't disclosed it, then we might well see a price movement at this time or no price movement at this time. And that would be something that we would point to if there was no price movement as evidence of lack of materiality. But usually we may not have something as helpful as that, so what do we do? Let's talk a bit about why we expect to see a movement in price if something is material. If there is indeed reduced state aid, the question becomes, how does that affect the price of the bond? Well, the issuer may still be able to provide the finances that it needs in terms of cash flows, but it is quite possible that the discount rate or the riskiness is now assessed as something even higher than what it was before. And so given that, the present discounted value of cash flows would be expected to drop if this was something that was material, something that would be important to reasonable investors, and if so, then we would expect to see a change in the price of the security had this been disclosed. Now, even if that's not disclosed at the appropriate point in time, if Smalltown County were to report the reduced revenue, say today, at some later point, we could use what we call an event study methodology to measure the present impact of that information. And assuming that other factors haven't changed the situation substantially between today and when the disclosure should have been made at some earlier point, then we could look at what happens when the disclosure is made to see if there is price impact. And if there is no price impact, then we would argue that this was not material. Let me talk a little bit more about what I mean by an event study methodology in terms of looking at price impact. An event study is simply something where one looks at what happens at the price of a security when some kind of news is revealed publicly or when some kind of disclosure is made, some kind of information is released to the market that could potentially affect the price of the security. In order to do an event study properly, what one does is analyzes something called statistical significance, and there are a few steps involved in that. The most important step is to look at the price movement following the event that we're interested in and identify the firm-specific component or the issuer-specific component of the price move. We call that the adjusted price move. What you want to do is distinguish that from the effect of overall and market and industry factors that would typically affect the security's daily price. Once you have that adjusted price, you compare the adjusted price move to what typically would have happened for the security or the typical volatility in the absence of any firm-specific news. And in doing so, you are answering the question, assuming that the firm-specific information that day was not material, what is the likelihood or the probability that we would expect to see a price move of such magnitude? If we would not expect to see a price move of that kind of magnitude in the absence of any firm-specific information, then we would argue that the information is likely not material. However, if we wouldn't have expected to see such a move, but we see a big move, then the information is likely material. If, however, the price movement is within the range that we would normally expect to see, even in the absence of any firm-specific information, then we would argue that the move is not material. So you can see in this graph that if there is a date at which some information is not disclosed or updated, but it is revealed at some later point and we see a price impact, then it's possible that if we find that this is outside of the range that we would normally have expected to see such a movement, then that price impact would be a measure of the movement that we would have expected at the time of the original update, the time that it should have been made. Now, what happens, though, if disclosure is never made? If there is no update or disclosure provided, and this is often going to be the case, then what can we use if there's nothing that we can observe in terms of the disclosure of reduced state aid, for example? Well, one way to do it is to perform the same kind of analysis, an event study, on other comparable disclosures. So the idea would be to look at similar disclosures of reduced revenue by other peer securities that are comparable to Smalltown County Bond Series 2010A. Another possibility is to look at similar disclosures of reduced revenue by Smalltown County Bond Series 2010A, or at other Smalltown County issuances if there haven't been instances of similar disclosures for this particular series. In this graph, you can see, in this chart, you can see that we've looked at 6 other issuers that have similar issuances, and we can see the kind of price reaction that occurred when we did an event study on a similar disclosure, and you could use either the average or the median to come up with what the expected impact would have been, if any. In this situation, we are seeing an impact of around 4.7 to 5.1%. Now, what are the limitations and prerequisites of doing this analysis? This becomes very important in looking at securities like municipal bonds. It is important that the prices that one is using are reliable. And I'm when looking at these considerations, they become particularly important if somebody like the SEC is asserting that there would have been a price movement, either by looking at available price data for the particular series at issue, or for the issuer, or for other similar issuances. The problems to keep in mind with municipal bond data is that you can often have very thin trading, and you can have pricing that's not directly based on trading, but is something called matrix pricing. And I'll get into more detail on what kind of issues there can be with that in a minute. Another problem is that the market must be efficient in order to reliably measure what the price impact of Smalltown County Bond Series 2010A's disclosure would have been using any of the methods that I've been talking about. And there's some other adjustments and concerns as well. Let me go into each of these one by one. In terms of the reliability of pricing data, the issues in implementing an event study for munis is that one of the key issues is that the lack of frequent trading activity in many muni issues means that it is difficult to observe movements in prices as munis may not trade for long periods of time. You have to be very careful about looking at price movements if the price movements are occurring, for example, long before or long after a piece of information that one is interested in. Multiple trades on the same day may also indicate very different values for the muni issue. And techniques that one may use in looking at other securities, like the closing trade, may not be the right thing to do here. It's possible that the closing trade, for example, is a much smaller trade than other trades earlier in the day that are more indicative of the value of the security at that time. It's also possible that the price of a single trade right after the announcement may be more reliable or less reliable than the price of a much larger trade later that day or the next day or the next week. It becomes very important to look carefully at the data that is available for any particular muni security and to not jump to conclusions, but to look at the bigger picture and figure out what is the most appropriate. Could we look at the next slide, please? It's slide 25. Now, issues in implementing an event study for munis. The first issue is matrix prices. This is the second issue. We've been talking about reliable and thin trading data. If we're using matrix prices for the event study, discrepancies between matrix prices from various providers can be a problem. Now, what are matrix prices? They're not actual trading prices. They're prices that are calculated by pricing services, and these prices are based on actual trading, but they're really extrapolations using various models on the dates that one may not have actual trading for. The courts have allowed the use of matrix price data when the movements of such estimates reflected movements in underlying prices. Now, before using matrix prices, you need to show that the changes in these prices do reflect changes in the actual prices. And there can be times where matrix price data can be quite unreliable, so you have to be careful about using those prices at those times. Next slide, please. Another key issue is market efficiency analysis. What do we mean by this? Let's look at the next slide. Market efficiency is something that economists analyze in terms of whether or not one can look at an event study and use an event study for a particular security. It's a prerequisite. And the courts have typically applied various factors to analyze market efficiency and to see when it can be presumed. However, the SEC has reported that the muni market exhibits features inconsistent with efficiency. Next slide, please. Is market efficiency a yes or no question? one thing that we found from a recent decision that Norm referred to earlier, the Halliburton decision, is that market efficiency is something that's a matter of degree. And so it becomes a matter of proof. And again, it's something that's very important to look at in the context of muni bonds, given that the SEC itself has raised the issue of whether or not market efficiency is applicable. Next slide. Let me back up and talk about what I mean by an efficient market. Next point. The stock price, if it reflects all publicly available information, is considered to be trading in an efficient market, and this would apply to bonds as well. This can include information such as past prices, information about company fundamentals, and other relevant factors. So a market is efficient for a particular security if new information starts to be rapidly impounded into the security's price. Next slide. Even if markets are efficient, one thing to keep important is that not every security trades in an efficient market throughout the relevant period. Next slide. Markets are not always efficient. There is potential evidence against market efficiency, such as lack of liquidity, few market participants, price movements that reflect mostly a bid-ask bounce, or a lack of trading following major news. Next slide. As I referred to earlier, the SEC has acknowledged that in muni markets there's potential inefficiency. And this is a quote taken from a report on the municipal securities market by the SEC in July 2012. Next slide. What the courts have looked at in terms of efficiency are the following factors. There's 5 factors that come from the Kammer versus Bloom decision and 3 from Krugman versus Sterrett and Unger versus MCDC. While these are factors that are conducive to efficiency, the key factors here in terms of what an economist would think of as an efficient market is the price response to news factor. Next slide. And in fact, academic research has indicated the following. Next point. The criteria that are supported by data in terms of efficiency criteria, in terms of the court's criteria, are trading volume and the number of analysts. Next point. But the ones that don't really hook up with the academic thinking on efficiency are the ones listed here. That said, these are also things that the courts do look at, and they're things that we can look at to indicate that if, for example, the SEC is looking at price movements and saying certain price movements are indicating a material piece of information that wasn't disclosed earlier, if you have an issue with respect to efficiency, then and with respect to these factors, then you may not be able to use price movements to make that sort of an argument. Next slide. Next point. Now, there are 3 levels of market efficiency that are typically discussed in the academic literature. The first is the weak form, which assumes that prices fully reflect the information implicit in the sequence of past prices. The second is the semi-strong form, next point, and that is that prices reflect all relevant information that is publicly available. And the last is a strong form, which is that prices reflect information that is known to any participant. However, what the courts have focused on is the semi-strong form, and that's where our focus would be when assessing market efficiency for a particular security. Next slide. In terms of the economic test for market efficiency, I come back to the strongest test is looking to see whether prices are responding to news. But there are other statistical tests one can do as well. Next point. So there's the price reaction to news. Next point. And then there are statistical tests of the random walk hypothesis. does the price actually move in a way that is predictable once you know previous prices, or is the price moving in a more random fashion? Next slide. The price reaction to news, as I said, is the essence of market efficiency, but one of the important things here is that testing for this needs to be implemented in a systematic manner. It may be difficult to implement properly with munis that trade less frequently, and it can be critical to get a handle on what price data you have and what price data is actually useful and trustworthy and can be used for this kind of analysis. Next slide. There are also statistical tests that can be done. These include overreaction and underreaction tests, serial correlation tests, runs tests, tests for other patterns. Let me tell you what I mean by this by giving you a couple of examples. Next slide. Next point. In an efficient market, if you have an event or a piece of news and the price moves dramatically and then stays pretty steady with some fluctuation after that, that would be indicative of an efficient market. Next point. But in an inefficient market, if you see that the price is actually not just reacting but then reversing itself and does this consistently, that would be indicative of an inefficient market. Next slide. Okay, we've talked about pricing issues when it comes to assessing materiality. We've talked about market efficiency concerns. What other adjustments and concerns are particularly important when it comes to municipal bonds? Next slide. One of the concerns is, does the price actually decline? As I said, if we have information for this issuer, either for the event in question or the type of event in question, or for other issuances by the same issuer, or if need be, looking at other issuers that have experienced similar events. One needs to, in doing the event study, make sure that you're using the right indices to control for market and industry events. One needs to adjust appropriately for volatility throughout the time period that you're looking at so that you know what the ordinary volatility would be. One needs to account appropriately for sparse and non-synchronous trading. And one needs to examine the response or lack thereof of all muni issues to the event, such as a missed deadline or the eventual filing. And next slide. And last, one needs to be very careful as to what the relevant event is. Is it a situation where there is a delayed disclosure, or is there no filing at all, in which case one would look at what happens with peers with similar announcements or by the issuer itself at different points in time. And with that, I'll turn it back to Terry.
Thanks, Nia. I'll try to spend just a couple of minutes talking about how we can put in context what we've heard today about the factors in determining materiality, and in particular, how does that help or hurt the SEC in proving its case, and how does it help us make decisions in whether or not to self-report. So, as folks know, determining materiality is obviously central to making a decision to self-report. And there are a lot of factors, facts and circumstances, as we're so wont to say, as is the SEC, in determining what materiality is and does it make sense in any particular instance. And so, I think we should take seriously Norm's point about does the SEC have the facts that it needs to prove a material misstatement when looking at the standards set out in TSC. And so we remember that they would have to prove that there's both been a misstatement, which involves a determination of materiality in and of itself, and then if there was a misstatement, was that material? So we need to think about it in that framework in determining do we have all the facts and circumstances necessary? So let's take a quick example. And this is similar to sort of West Clark, where we have a school district that has not made any disclosure. But if we look at all of the circumstances, that is and this is a different school district, this school district were to get all of its revenues from the state. And the state clearly set out in its CAFR that the information that was going about what was going to the school district, and all investors went there anyway instead of to Emma to try to find that information. It may be difficult to say that there was any effect on price, given the fact that every investor had the information that they would have otherwise gotten. And I think that as we look through the lens of what we talked about today in terms of materiality, that may color whether or not we find a complete failure to file to be particularly material. I'm not saying we wouldn't. I'm just saying there are sort of facts and circumstances that look through these lenses may change things. To Nita's point about price in just a couple of instances, I think everybody's agreed that a bond insurer rating, if not disclosed by the underlying credit, is likely not material because everybody in the marketplace knew about it. And so there would be either the disclosure by the underlying issuer or obligated person would not affect price. It wouldn't affect what we see happening in the marketplace. So I think what we have today is another tool in determining those facts and circumstances in where we look at are we getting to a material misstatement. And then I think it's also one of the facts that we need to look at in determining whether or not a determination to self-report makes sense. Because as Norm and John both pointed out, the SEC has to prove its case. And there are a lot of factors that sort of go in with that, and this is one of them. So compliance, as we know, with MCDC is, the initiative is voluntary. And John, if you'll go to the next slide, it really is based on a variety of factors. Are both the underwriters and issuers filing? And are they saying, if they both are they going to say the same thing in Section 5 of the questionnaire, which John pointed out to us before? Because we want to make sure that everybody's kind of looking at the facts and circumstances in the same way. If you'll recall, the SEC doesn't have a definition of materiality, and in the 94 release, defers to working groups to make that decision. So when you have the working group who's talking about what is material, I think that's important that everybody's on the same page about that. And then when we think about is the issuer, and when we say issuer, we mean obligated person, of course, as well, are they prepared for the consequences of filing? One of those options, as we've talked about today, is really, can the SEC prove its case? So a factor in determining whether to file is, if you go ahead and file, you are subject to potentially cooperating with subsequent investigations, disclosure of settlement terms, establishing policies and procedures, the publicity, potential liability against issuer officials, as all stated here, but also potentially deciding, are you willing to take the consequences of that versus deciding whether or not the SEC could prove the case even if they brought the case against you. And the answer may be that the SEC doesn't have enough information, put through what we've seen today, the TSC filter and the pricing filter. So, John, I'm going to turn it back over to you to wrap up for us in light of our practical applications of what we've learned today.
Thanks, Terry. Everyone, the issue of materiality is obviously a threshold issue in terms of the SEC's burden of proof, and I think as has been demonstrated today, conclusive evidence of materiality may be elusive. And ultimately, whether the SEC can prove its case in court is only one factor, albeit a critical factor, in determining whether to participate in the initiative. Indeed, the issue of whether the SEC can prove its case in court presupposes several steps each of which has some expense, sometimes great expense, associated with it. It presupposes an investigation. It may also presuppose the filing of a complaint and the conducting of discovery and civil litigation. On the other hand, particularly where the SEC has limited resources, and it indisputably has limited resources, strong arguments can be made that materiality cannot be established, and that may discourage the SEC from pursuing an enforcement action in the first place. We are very grateful to everyone for your attendance today on our webinar, and we welcome any questions that you may have. If you do have any questions, please do email us and we'll get back to you as soon as we can. And then, as I think you all have seen on the site, we'll be sending the slides around to everyone so that you can catch up on anything that you may have missed. Thanks so much.